Thank you very much. First, I apologize for not being able to speak in Spanish, but I'm grateful you have the translation services. Thank you very much for having me here. When I left my home, there was snow everywhere, so it's very nice. It's like coming to Hawaii. I was very interested this morning to listen to the speakers and learn that many of the themes you are struggling with, we are also struggling with. We presently in Canada, and in my province for sure, face significant challenges in the civil justice system, and they are challenges that affect access to justice, even equality before the law. Our civil justice system has become very complex, very slow, and too expensive for many individual claimants to be able to afford. This results in a large amount of self-represented parties in our system, particularly in divorce cases, and they have the disadvantage of no legal training, and it is a further disadvantage since it is a very large burden to the court system, taking more time and more resources. I was interested to hear what Marco described this morning as Cadillac cases, because we have that too in Canada, and it is a case that the wealthy are opting out of the system, the wealthy and the big corporations are opting out of our civil justice system and going to private arbitration to settle their disputes. They then get to choose their judge. They have privacy. They, as Marco said, the case does not serve as a precedent for the community, and the community is not able to see what is the result of the litigation. For my presentation this morning, I have been asked first to provide a form of overview of our traditional civil process, and secondly, to speak of some innovative approaches. In general, I think it's fair to say in Canada, we're moving away from the traditional formal adversarial litigation process into one that involves alternative dispute resolution. And I think, as Jaime has pointed out this morning, I believe it was Jaime that said this, it can result in a form of second-class justice. In divorce, we have collaborative law initiatives, which I will explain. We also have small claims court, which is something like the People's Court. We have, in my province, a piece of legislation called the Fair Trading Act, which helps to level the field for individuals to be able to bring their own cases. And then we have increasingly class actions. I was also interested to hear Gonzale's presentation this morning on civil jury trials, because we have moved those almost into extinction in Canada. And in part, I believe it's because they're very expensive. We can no longer afford it. They're time-consuming. They require a great deal of resources, and they have uncertain or erratic results. So I'll be interested to follow what is going to happen here. So moving to my more formal presentation, each province and territory in Canada has a superior court that's guaranteed by the Constitution. We've inherited our system of justice from England, and we have what's called plenary jurisdiction that we've inherited from Law and Equity in England. So we have broad jurisdiction in our court, which is the trial court. And in our court, we do everything from very serious crime, gang-related crime, murder cases, all the way through to divorce and very simple or smaller civil matters. Courts in Canada can have their authority that I've just described, the plenary jurisdiction, added to or taken away by provincial or federal legislation or lawmaking by the governments. The lists of kinds of matters that are included in our inherent jurisdiction are contract disputes, torts, which are like motor vehicle accidents, for example, property disputes, divorce proceedings, surrogate or matters having to do with death, wills, judicial review, which is that we have the jurisdiction to review all inferior tribunals, labor boards, other forms of that very broad matrix of statute law that has created other methods of governance in our jurisdictions. And I think the best example is the Labor Board or Workers' Compensation Board or any of the decisions that come from inferior tribunals. We have the jurisdiction to deal with them on review. It's a form of appeal. And then finally, constitutional questions. In addition to that inherent jurisdiction, we have statutory jurisdiction, as I'm sure you do. And there is a list that I've given as examples of the kinds of powers we can exercise in order to solve different kinds of disputes or cases, because the statute gives us that power to do it and tells us how to do it within certain parameters. Again, builders' liens, divorce is governed by statute, expropriation, landlord-tenant, bankruptcy. There's a long list of those statutory powers that we have. Our Superior Court then has different forms of relief we can give, depending on, of course, the nature of the case. And we hear trials, but we also do all of the interim applications between when the case first begins and the matter comes to us for the conclusion of the process in the form of a trial. All of this civil process in all of the provinces are governed by what we call rules of court. In my province, and it's not different from any other province, there are two large tomes that are simply providing procedural rules, not substantive law. And the goal of those rules is to provide a method whereby we can get to trial quickly as possible, though I've indicated it's really slowed down, in a fair and just resolution that's cost effective. That's the goal of having the process. So if you were acting for a party in a civil claim, a wrongful dismissal claim like the one that was being discussed in the jury trial, it would begin by filing of the statement of claim and then take it all the way through a number of procedural steps which you will find in the rules until the matter is ultimately resolved at trial. There are fundamental principles set out in our rules of court, and they are identified there for you on the PowerPoint. But again, the idea is to use civility among lawyers, among the parties to the case, to try to come to a good and just solution as quickly as possible. A new addition to our rules is the requirement that in each case, the parties must consider a form of alternative dispute resolution before the matter will be set down for trial. In other words, a real effort has to be made using one of many processes, but a real effort has to be made to try to settle the case before it comes to trial. I've set out for you also, as a matter of interest, the steps in the civil action. This is probably not unlike what you do. First of all, there's the pleadings, which are the documents that go back and forth between the parties. The claimant files the claim, the defendant files the response. There can be a further document filed by the claimant. Other parties might be joined into the action, and the initial claimant might also sue, the defendant might also make a claim against the initial party. In the next stage of the process, there must be disclosure of all of the records that are relevant to the proceeding. This is largely a paper transaction. If the parties don't agree on what is relevant and material to move the matter to trial, they can come to court and get an order to decide whether any particular piece of paper might be privileged or if it's relevant or if it must be produced, and we will give an interim order. Once the records have been produced, the parties then move into it used to be called discovery process. You're discovering the other party's case. Now it's called questioning, and it occurs outside of the court process, usually in lawyers' offices, and everything is recorded by court reporters. While this matter is proceeding and getting ripe for trial, we do have something called case management, and I was interested to hear that you're thinking about it or you have it in some locations. Case management for us is for dealing with the most difficult cases, or if the parties, for example, in a divorce case, are simply unable to get along, and sometimes the lawyers are unable to get along, and there is so much money and time being spent, and it's taking so long to get resolved or get to trial, then they will appoint one judge to be in charge of that file. It takes us a great deal of time. For example, our workday used to start, we would get to court and start at 10 o'clock and spend the morning preparing for our trial. We would be sitting in trial all day till 4:30, then we would have probably further preparation for the next day. Now, most mornings starting at 9 o'clock, we have to deal with our case management files. So they effectively have a judge on demand to solve the problems that they have in the litigation. And on the one hand, I do think it has made the court process more smooth in the sense that my colleague next door doesn't have to deal with this really terrible file that I'm very familiar with because I've had it for 12 years while these kids are growing up. And I'm not exaggerating. Sometimes in a very contentious parenting case, we might keep the file as long as the children are still with the parents. So it does make it easier for those cases to be dealt with, but on the other hand, our workload has substantially increased as a result of it without more judges. We also have in some jurisdictions, we don't have this right now, but pretrial conferences that assist the parties to set the issues for trial, deal with anything contentious before it gets to the courthouse steps. Then, of course, trial and appeal. We have a chart which shows in a more graphic form all of our processes. Step 1 is the pleadings. Step 2 deals with the information gathering necessary to have the litigation proceed. On the left hand, you see chambers applications, which is every day in our courts, there's divorce chambers and there's civil chambers so that people can come forward with the interim applications to get small problems solved in a 20 minutes in front of a judge. And there might be, well, we're quite often in morning chambers from 10 a.m. till maybe 12 o'clock, dealing with people's 20-minute applications on cases to get an order and get on with it. And then on the right-hand side, you see settlement. As I've indicated, it's now required that parties go through a settlement process. And finally, we are pushing these matters on to trial. I'm going to scan over so we don't run out of time here. Too much depth here about the rules of evidence, but I'm going to say again something general here. The underlying purpose of the trial process is to search for truth. The intended purpose of the evidentiary rules that have developed are to facilitate that search for truth. I would say generally in the years that I was practicing law, about 25 years, I've been on the court now 14 years, there's been an increasing move towards more relaxed rules of evidence, towards more openness, towards less fiercely adversarial process. So at the same time as we're moving in the general direction of trying to use alternative dispute resolution so that matters never have to go to trial, we're opening up the processes of sharing information with each other so nobody is sandbagged, we call it, or ambushed at trial, so that everything is known before you get to the court. You can assess your position and see where the settlement might lie. So the evidentiary rules have changed, broadened, become more flexible, loosened in order to accommodate the direction that we're going generally in litigation. So rules of evidence, as in your courts, I'm sure, it determines what is admissible in court and how it's going to get admitted. Most of our rules of evidence come from the English common law system again, and most of them you can find the root of them years and years ago in the Wigmore rules. I don't know if you are familiar with those, but they came to us from the English process. But we also now have those rules of evidence modified, updated, as I say, made more flexible by what we call judge-made law. And many cases on evidence will end up in the Supreme Court of Canada, and they'll give us a direction or a thrust as to the way in which we're going. And as I've indicated, more and more disclosure now is required, and more types of evidence are admissible in this search for truth. I've given you a couple of examples here. One concerns the issue that often arises, for example, in a medical malpractice suit. How are you going to prove 2 weeks' worth of nurses' records that may have been taken 10 years ago by an unknown nurse who knows where she is now? It used to be, under the old rule, the person that actually created those notes would have to come to court. Now it's assumed that the records that are made in the ordinary course of business are admissible in court unless there's some legal reason to object. So again, it streamlines the process, it opens up the medical files, and it gives everybody an opportunity to see what's happening or what happened that created the harm that is the subject of the litigation. Another example here relates to the old common law rule of privilege. Only the solicitor-client privilege enjoyed the protection of the law historically. And slowly there's been an eking away of that rule or broadening of that rule so that there are social policy reasons around what other types of communications might be found to be privileged and not shareable with the other party. Now I come to the question of judicial dispute resolution. I've mentioned that under our rules of court, the parties are obliged to try some form of dispute resolution. We have, in my province, been innovators in the area of judicial dispute resolution, where the judges are actually involved in trying to get the parties to resolve the dispute. So the goal is to find a just result without too much second-class justice, as Jaime would say, but with speed, efficacy, and with modest cost. So I'll take you through how this might unfold in my court and how I would do it. First of all, these are highly sought after days, our judicial dispute resolution days. In fact, sometimes it takes longer to get in front of a judge for judicial dispute resolution than it would be to get in front of a judge for a trial. And it's almost a lottery system. People race to the computer the day the dates open up, and they sign up, and they try to get the judge they want. There's some judge picking, but if you can't get the judge you want, then the parties will go to the next judge on the list. The next thing that will happen is that the parties will meet with the judge that's assigned, and they'll talk about that judge's practice in doing these types of cases. Normally the cases take only a day, but there are long ones, or I had one, for example, a very complex motor vehicle accident that involved a brain injury child as well as the parents were injured. And so that case took over 2 weeks, not sitting all at one time, but 1 week first and 1 week way down the road so the parties could think about some of the progress that we had made in the discussions. There were about 8 lawyers involved, maybe 3 insurance companies, and it was just a long, hard process of sitting in a room day after day with each party, presenting their position, hearing from the other party, talking about what evidentiary holes there were in one party's case or the other party's case, and trying to work slowly towards a common ground, both on facts, on law, and ultimately with regard to a damage settlement that might solve it. So there's different ways of doing it. My own preference, and I've listed them here, there's traditional mediation style where you're sitting in the room with the parties. Let's take a divorce case. And first I'll explain my style and then I'll talk a little bit about the other styles. But after I've met with the parties the first time, I try to find out, because it's in the absence of the clients, in this case, for example, the divorcing parents won't be there. So I try to really get from the lawyers what they're really thinking about this case, not posturing because their clients aren't there. Then I tell them what my process usually involves. They have to provide written submissions by certain dates. I tell them, don't give me too much paper. All I want is one brief each. I want the top cases, maybe 3 cases on the point that's really in dispute. I want excerpts from questioning, transcripts, a couple of pages just to support your point. And I want the 2 of you to get together and write up an agreed statement of facts as far as you can agree, okay? So that I don't want yours and yours. I want one common agreed statement of facts. You 2 have to sit down and agree on facts until it comes to the point there is no agreement. And so that's the framework for when we get into the room. And I also tell them, you have one chance here to get a solution short of trial, and so we have to work really hard to do that. So then when we arrive the morning of the hearing, we insist that if it's an insurance company, for example, they have somebody there with the power to make a decision. Otherwise, it's a pointless exercise. If they have to make a phone call to Toronto to get authority to spend money, it's not going to work. So the insurance company, for example, has to send someone that can make the decision, and the plaintiff or the claimant is actually going to be there, and they can both see the whites of each other's eyes, in other words, like they can see each other. And for the first time, possibly, the person with the power in the insurance company is going to see the pain or the harm that the individual has suffered. And maybe it's not true. Maybe it's not true at all, and maybe it's going to expose that there isn't much of a claim there. But everybody is sitting there. So I'll begin by opening and asking them all to work hard today, try very hard, try to be reasonable, try to see the other person's point of view, and please express yourselves. Those sorts of opening remarks. Then I hear from the claimant's lawyer, and then I hear from the claimant his or herself, so that people really need to be heard. They need to have their story heard, and they need everyone to understand what it is that why they're here, what it is that they've suffered, where the wrong lies. And so my role there is to encourage the parties to bring out their point of view in a very comfortable place where there's as little conflict as we can possibly have. So if you have 2 parties that are recently separated, maybe within a year, it can be difficult. Like, you have to try to have them appeal to the better angels of their nature in that room and try to, understand their point of view, but nudge them back to reasonability, right? That's the job of the judge. So after that side is finished, then we turn to the defendant's lawyer, and they make an argument, and then we hear from the defendant, his or herself, which would be the insurance company in a motor vehicle case. It would be the mother or the father on the other side of a divorce case. And it's all very informal. It's probably the hardest work we do, though, because you have to bring in all your resources, everything you've ever learned as a lawyer, judge, and human being. Psychology, sociology, persuasion, art of persuasion, the intellectual side. What do you know about the law? You bring everything you have to that situation. And as judges, we're not used to sitting 2 feet away from the people that have these problems, right? We put ourselves up on the bench here, and we're many, many yards away from the people. We're this distant party. No, we're actually right down there, and they have to trust us, right? So you have to use all the skills and facilities you may have learned all the way along the line. So then, if parties are becoming intractable, they're not moving off their position, I can see where the dynamic in the room is. And we have this quite often, interestingly, with in-house lawyers at insurance companies. They think that it's their own money they have to defend. And they are like talking to a brick wall, So then we'll take a break, and then I'll ask people to go into separate rooms, and I'll go into that room, say, with the difficult parent or the insurance company in-house lawyer, and I'll say, look, you have a problem here. You're not going to be able to prove that, that this person was behind the wheel. You're not going to be able to prove that. It was a fatal accident. Could have been one or two people. No, one guy's saying the other one was driving, the other guy's saying the other one's driving. How are you going to prove that? The evidence doesn't show that. Or whatever the fallibility in their case might be. I'm going to point that out in the caucus meeting, or I'm going to say to the mother or the father who is opposed to shared parenting, when there's no reason why there shouldn't be shared parenting, I'm going to say, look, you're going to go to trial, you're going to fight for 12 days, there's going to be lots of stress in your house, your kids are going to know what's going on, and chances are you're going to lose the point. And so we need to go in there and talk about how we can do this in a way that is not going to be so painful for you, you know? So that's how I do it in any event. And there's no one size fits all. It depends on the personality and the proclivity of the judges. Some of the judges on my court hate it. They don't think it's a judicial role at all. Usually they're the old gray guys, I must say. Like they're from a different generation. They saw judging as a different thing. My argument is, we have to do what the community needs us to do as judges. We have to serve the community, and now we need this as part of our process. So coming back to the different types, in my own way, I use a combination of the first three kinds: facilitation, conciliation, and evaluation. If at the end of the day, it's 3 or 4 o'clock in the afternoon, we've been talking all day, they're at an impasse, there's not going to be a resolution, then I take a break and I go collect my thoughts, and I will have prepared this in advance, and I give them a little mini judgment. I say, look, this is not your trial. I haven't heard you want to speak under oath. I haven't heard all the evidence. But if I were hearing this case with this amount of information, this is what I would do. This is the direction I would lean. And I try not to make it cast in stone, so there's still some room for them to discuss settlement. But that would be what we call here mini-trial style. And then, of course, there's the hybrid, which is my approach. And I must say that background in labor negotiations was of some use to me in learning how to do this. But you never know it all. Like I have been doing it 14 years on the court, and I still want to learn. I'm signing up for a course next year to learn, because there's so many advances in this area. So next I have a list of benefits of this process: alternative dispute resolution, significantly reduced costs. It does give a form of justice, and again, maybe a two-tier form of justice, but a form of justice. We find where we reach success in most cases. Most cases we leave and it's settled. And many times in my own experience, they shake my hand and they say thank you, because there is so much relief to be out of the system, to be finished. And we used to say in labor relations, if everybody's a little unhappy, you know you have a good settlement. I mean, they're never always happy, right? Because sometimes the lawyers give them false or inflated expectations, and they think it's going to be their $1 million day, and it's nowhere near a $1 million case. But the reason it works is they have respect for the judicial system. They think judges know quite a lot. Whether or not we do is up for debate, but they think we do. And so, as opposed to the informal system of mediation you might get out in the private sector, when we walk in the room, there's a perception that we have power, and there's a perception that we know what goes on at the courthouse. Like, quite often I'll say to them, well, I'm only one judge of 35 judges here in my city, and I'm just giving you what I would do. I'm giving you my opinion, but I think it's pretty representative of what would be the result if you come to the courthouse and you have your trial. Oh, and by the way, it'll be $100,000 down the road by the time you get to trial in this difficult, complex litigation. Is it going to be worth it? You have to talk money, cost of the process. So, problems with it. The first problem, I'm not sure I even noted it here, but a really big problem that I see is that lawyers are losing the art of negotiation and settlement. I see that as a really big problem. I see cases come that I'm determining in a judicial dispute resolution that in the days when we were in practice, you would have had that case settled and solved and put away. But now they think they have someone else to throw the problem to. They don't have to manage their client, right? So it takes away a lot of stress from their job, the lawyers I'm talking about, to go to JDR. because it's throwing it on the judge's desk. So that's a problem. We can't meet all the need for JDR. Demand is greater than supply. I said earlier that there's the Cadillac cases that were referred to earlier, but private dispute resolution is not preferred for most everyday cases. Why would they pay to have someone solve the case if they can come to us with our high success rates? So that's unfortunate, because we would prefer that some of the cases were still going to the private sector. It's hard to get time when we're in the rural circuits to do JDR, because it takes a full day out of the circuit, so we're short of providing those services in the rural jurisdictions. We're not really set up yet to do this in as good a way as we would like to in our physical structure, in our physical courthouse. Our training processes, except for when you first become a judge and you have to go to what we call baby judges school. You go to 2 sessions, 2 weeks of baby judges, and then everything else for training after that is voluntary. And so it's up to you. What do you sign up for? What do you not sign up for? It depends where your needs are. We don't have consistent and required training. I'm pretty sure if George is listening, he wishes that we did, but we don't. And so not everybody has even been to the elementary form of training for JDR, and that's significantly going to affect the level of success. I mentioned some judges hate it. They think it's unethical for us to use our powers as a judge to try to, and it isn't impose, but they would see it as impose a decision upon people that's not based purely on law and evidence. They think that that's abusing our role as judges, and again, I don't agree with that perspective. And there have been a few cases where people have been unhappy with the JDR. They've appealed to the Court of Appeal. There have been rulings on that. I've not personally ever heard of a complaint to the Canadian Judicial Council, but I understand there have been some, not on my court, that I'm aware of. Next, I want to talk a little bit about collaborative family law, and I'm going to really be speaking third party here, because of course I was not a divorce lawyer, and this is only a recent innovation in the family bar. It is, though, being very warmly embraced by our most senior and experienced family law lawyers. And the idea is that more harmony would be used, or more, efforts to have the parties get along rather than litigate and be adversarial, in the best interests of both parents, both parties, and in particular the children. So the idea is to have, you'll find now where I live, you'll find family law lawyers who specialize in collaborative family law. They do not go to court, and when you engage in collaborative family law, you cannot go to court for the period that the collaboration is ongoing. And it will result in a full and fair exchange of information, and it will result in what are called four-way meetings. So the 2 parents or 2 parties to the marriage and the 2 lawyers will sit in a room and try their best to use civil processes, civility, getting along, using sort of psychological tools to try to get people to see in that room, the parties in that room, to see each other's point of view, to see each other's interests. And the idea is to have really a bloodletting in a very civil fashion. That is to say, get everything out there on the table, express what it is you're feeling, find your interests, exchange them with the other party, and do all of this under a very civilized mantle. So the lawyers have a very big role in this. They need to know what position they want to ultimately end up at. They provide legal advice to their party throughout the process, and they try to quell any conflict by really responding to it, like answering the problem there before it blows up into something nobody wants to see. So next, I gave you a divorce example, thinking we could have, to please George, a few minutes of interaction here. So I'm going to give you a minute to read this, and then we're going to talk about it from a traditional perspective and a collaborative perspective. How's my time, Jaime? Are we good? Okay. This is quite a typical short-term marriage divorce case where the mother has the parties have chosen for the mother to stay home when the children are young. She will have sacrificed her career aspirations. The husband, meanwhile, is moving along with his career. Then something happens, the parties separate. Mother thinks that because she's been primarily at home with the children should be primarily with her on separation. More and more in Canada, the father is asserting a right to shared parenting, and in fact, the Divorce Act encourages that because it mandates that we make decisions which will maximize the amount of time both parents spend with the children. So there's a conflict there. And so that's a very typical fact scenario. So on the next slide, I'm asking you, what do you think the litigation result is? And should I ask the parties, Jaime, or should I just go forward? Go forward? All right. First of all, on the parenting side, chances are in that type of scenario where both parents are fit and qualified to parent, and both of them can provide a home and all the needs for the child, the result would be a shared parenting regime. Child support. This is very interesting. I don't know whether you have this, but our method of giving child support orders now is formulaic, and it is so efficient. I mean, it's even become more efficient in the years that I've been on the court. It was already more or less in place. But it's based on what we call line 150 in the Income Tax Act, which is the payor, the party that is making the money, and usually it's the non-primary parent. You just plug in the income from the income tax documentations, and it tells you what child support is payable. In terms of the special expenses, the other things like the ballet lessons or the skating lessons or the orthodontics, it's shared by the parties in proportion to their income, so that too is formulaic. Spousal support, very difficult problem. You take into account a host of factors. We are moving again more in a formulaic direction with spousal support, and we have advisory spousal support guidelines. These are wonderful and efficient because when I started, we didn't have this at all, and it was like pulling a number out of the air. Took so much time, so much thinking. Now we have these spousal support advisory guidelines which show you the income flow depending on what you decide on spousal support. So who's got what disposable income at the end of the month? It saves so much time, and there's a listing of options or choices that you might decide to order as spousal support, and it shows you what amount of income ends up in each household. So if you have their budgets and they're legitimate, it cuts out so much time, and you can find out what you think is a reasonable solution. And finally, when you're deciding whether to go the litigation model, the collaborative law model, or the judicial dispute resolution model, of course, costs means everything. And one important thing that we say all along this process to people, we would rather the money be in your pocket than in the lawyer's pockets. and so try these processes to get a solution. So the next slide tells you what this looks like in a collaborative law scenario. What Jessica's feeling, fear of financial insecurity, concerns about the needs of the children given Dad's proposal for radical change, anger at her role as a mother being dismissed in favor of nanny or old grandma. You do get a lot of women who feel, because they've been there by joint choice, they've been there with the children all these years, it just seems so unfair. But quite often you have to use powers of persuasion because it isn't necessarily the right answer for the kids. Need for acknowledgement for having put Gary in place of financial security, in this case putting him through school, but often this is the case where the woman, typically it's the woman, is in the home looking after the children, cooking the meals, doing the laundry, thinking one day we'll be retired and we'll have our nest egg. Meanwhile, his career is blossoming. So those are what she walks into this collaborative law session thinking. Those are her interests. And then Gary, on the other hand, he's terrified. He's never going to see his kids again. He's concerned the rest of his life will be paying. He's fearful because he's the person going to be judged in the legal setting because he's misbehaved. And there is actually a provision in our Divorce Act that conduct is irrelevant, right? So in this process, I'm sure their lawyers say to both of them, I always say this, I said it at a divorce trial last week. The female partner kept talking about that had been domestic abuse at the point that he left the house and she stayed behind and they were separated. I kept saying, that is not relevant to the issues I have to decide today. That's like 5 years ago. And yes, it may have been painful and difficult and he's, hopefully changed since then, but it's not relevant to what I have to decide. So in these settings, same thing. Everybody's got a long history of baggage they want to bring to the table. It's not relevant to trying to get a settlement. You might have to hear some of it. You might have to say you understand, which we all do, but you have to move beyond those those points of explosion. So that's how the collaborative law process works. I have quite a few more little issues to raise here. Jaime, is there time? Shall I carry on? Okay. I'll just check what I've got here. I'll just carry on. So, leaving alone then those innovative approaches, I wanted to talk a little bit, or was asked to talk a little bit about small claims court. This is not our court. This is the entry-level court in the Canadian jurisdictions. We don't like to use the word inferior, but it's the entry-level court. They don't have plenary jurisdiction like we do. They have limited jurisdiction over civil claims, debts, things like unjust enrichment, property issues, small contracts, specific performance. You can litigate there up to $50,000. So sometimes, a case I had recently after dealing with some of the interim applications, the ultimate claim in that case, which was a renovation gone bad, was going to be on the best day $75,000. I said to the lawyers, you shouldn't be in this court. You should go back to small claims court. And I didn't include it here in the note, but, it's on the next page. So we'll go to the next page. This idea that there's no discovery in small claims court. So you don't get the opportunity to question the other party prior to getting to the court. Presumably most of them are simple enough cases that you bring your bundle of documents with you and you know the case well enough and as a self-represented litigant, and you have that trial. It can take a morning, it can take as much as a day, possibly even more, but usually they're straightforward cases. Everything is relaxed in that courtroom, and as I was saying, mostly self-represented parties there. There's also provision for the court to direct the parties to go away and try and solve the case through mediation. And this is all contained in the Small Claims Court statute. Okay, next I wanted to talk just a little bit about the Fair Trading Act, which is quite a new piece of legislation in the jurisdiction where I live. And again, it's designed for the use of self-represented parties and it can be used in small claims court, or it can be used to assist in trials and claims in superior court. And it's effectively consumer protection legislation for small contracts. And everything, again, is in this legislation. You have the ability to challenge the terms of a contract, whether there's a breach of contract, whether the other party has performed the contract or not, by filing civil process in the courts, or you might file it as a breach of contract case and bring in the Fair Trading Act and plead the Fair Trading Act in your pleadings. Something that's extremely important as a result of this legislation is the ability of the claimant to get behind the corporate veil, so that if there's a company that traditionally you sue a company, you can only realize your remedy by getting a judgment against the company, and you can't get the individuals. And so an important part of this legislation is to permit the judge in certain cases where it's just and right to do so, to award the damages jointly and severally against the company and against the individual who's behind the company. So I gave you an example here of a Fair Trading Act case, and this is one of my own cases that I did recently. I just thought it was an interesting idea using this Fair Trading Act because again, it was a renovation gone bad on a dream home type of case, and it started out with a contract between the family and the renovation company, in this case called the Renovation Store is what it was called. So they sued on the contract because there was failure of performance after failure of performance, and the contract was worth something like $98,000, and the family had paid about 3/4 of it, and the renovation was a mess. They had taken out supporting walls in the home, and the floor on the second floor was of this home was slanting permanently, and they had not done the paint job properly. They had delivered the wrong appliances. Almost everything that could go wrong did go wrong. And it was a modest family, and they had been in the home decades and done nothing to it, waiting to make this home their dream home before they retired. So they were very, very sympathetic claimants. So they brought the case in our court, based on breach of contract, and they claimed the Fair Trading Act. And of course, by this point, the company itself, they assumed, probably had no assets in it whatsoever. So by virtue of the Fair Trading Act, there was able to be a damage assessment against the person, a couple of people who were running the business. So it really did streamline for the claimants the whole process and get them a result that they would not have been able to have otherwise. Next, I wanted to talk briefly about class proceedings, class actions. These are becoming more and more popular in Canada, and I must say, in terms of achieving civil justice, I think it's a very, very important innovation. Really what it does is it allows large groups of people that have suffered harm, but as individuals would not have the means or wherewithal to bring an action against a large adversary, a large corporation usually it is, it allows them to bring a representative case. Lawyers are interested in doing this for contingency fees because the pot at the end of the rainbow is clearly significant, and it's going to mean that they will get their fees. So you have, I am in the middle of case managing one right now that involves a claim by senior citizens in the province of Alberta who say that the province of Alberta raised the fees in their senior citizens' homes without consultation with them and without empirical basis to do so, that it was just a method to get some money into the healthcare system. And so it's taking many years to get this claim to trial, actually, but it's the kind of claim that's, perfectly exemplar of how the individual senior citizens could never do this on their own. They could never claim that money back on their own, but when the whole class is doing it, they can afford to fund the litigation, they can afford to see whether or not there's merit to the litigation, and they can take the thing onto trial. On the next page, the purpose of it is, of course, again, to avoid duplication of legal proceedings so that we don't have 100 claims going after the same wrong or the same harm by the same individual. It definitely improves access to justice because people can all of a sudden afford to take on the big adversary, the McDonald's, for example. And it does bring the big adversaries, the corporate entities, into line. And I think we saw some behavior modification this morning. It sounds like McDonald's improved its methods of delivering its coffee at not too hot temperatures. So that's the goal. It's also got salutary public policy consequences. So I'm using as an example, not my case, but actually a more interesting case that just got resolved in Alberta. In this case, we have a system of social, what is it called? When children are in danger in the home, the government sometimes has to apprehend them, and they become wards of the court or wards of the government. And so the provincial government takes responsibility for these children and finds them placements either on a temporary basis or on a permanent basis through adoption. This has been going on in Alberta for a very long time, and I know my friend and colleague there, George, was involved in this process in Ontario. We were talking about it last night, and you know, it's a common phenomena right across the country where the government, of course, is responsible for the children and to make sure they're not harmed. So in this case, a sample person brought forward the claim against the government that the government didn't do this properly looking after the individual children's needs. And in fact, there were many, many cases in Alberta over the 2 decades involved here of child abuse in these foster homes, of physical, emotional abuse, similar to what you will have heard of the residential schools cases, where lawsuits came decades after the fact where First Nations children were abused in residential schools. This was a similar type of case. And so the plaintiff brought this action in a representative capacity. The first thing that happens is the issues are defined, the class of people who are affected by the harms is defined, and there's a certification of the claim so that a judge looks at it and says, yes, there's merit to this claim, yes, the issues are properly defined, yes, that's the proper class to bring this case, and it can go forward. And so there's judicial supervision every inch of the way. In this case that I'm describing, you can see the suffering that was claimed for went from 1966 until 2008. Ultimately, there was a settlement between the lawyers and the example claimants and the government. And now it's the case that individuals who have not opted out of the system, who want to bring their individual claims, can do it because the parameters of the case have been settled and approved by a judge, and the settlement itself has been approved by a judge. So on the next slide, you'll see that there were about 36,000 members in this class, children that were harmed within that defined period. 6,500 estimated number of class members who suffered abuse captured by the settlement. So I haven't seen the settlement, but presumably just certain kinds of abuse were seen as part of that particular lawsuit. It is expected 2,000 people will make claims under the settlement. Some of them will be denied when they bring their individual claims forward because they don't fit within the parameters of the class action. And it is expected each of the claimants will get $20,000. One last thing on this class action, this whole subject matter. I was reading in one of the American media publications just the other day that, of course, the corporate entities have figured out a way around it. And if, for example, you're suing a large telephone company in the States, and you're entered a contract with a large telephone company in the States, the fine print may include a provision that if you have any difference with the service provider, if you have any dispute with the service provider, that you have to go to arbitration. And so high levels of court in the United States have held that those are good defenses to class action claims. So I think to get around that, you'd have to have some legislation, and I haven't seen it yet. Maybe we'll start thinking about how we might get that.